All right, I think we should be good to go.
Excellent, Paul. Thank you. Good afternoon, everyone. Thank you for taking a seat and joining us today. My name is Rick Salagi. I'm the Executive Director for the New England Livery Association. And some time ago, we were fortunate enough to benefit from a grant from the Commonwealth of Massachusetts, which gives us the ability to contract with certain providers of services. And MP is one that we're extremely proud to be working with. MP provides a high level of HR services to providers in many industries, including our industry. Today presenting is Paul Carelis. Paul has over a decade of experience in HR consulting, working with businesses of all sizes and industries. And his team of certified HR professionals at MP assist clients with compliance, training, and full circle HR guidance and support. And today, Paul will be concentrating on helping us process and how to think about challenges that we're facing relative to the pandemic within our ground transportation companies. Paul, thank you.
Thank you so much, Rick. Great to talk to you again and excited to present on this topic. So really challenging times. It's been whether pre-pandemic or during the pandemic, or hopefully as we start to exit the pandemic here, just numerous challenges to the industry. So we really wanted to focus on kind of an update in terms of what's going on with COVID, talk about, and then kind of talk about government regulation across all industries, both at the national and the state level, as well as at the various agencies that can affect HR and employment law, and try to wrap the conversation around, which of any of those are of particular interest to livery industry and association, and kind of how to navigate those and what to be on the lookout for in the year ahead as we're just now kicking off 2022. So quick legal disclaimer. While I wish, I am not an attorney, so please don't construe anything today as legal advice. This is all coming from an HR best practices perspective, and I hope that you enjoy the content. Also, in case you're watching this via recording, and because so many of the rules and regulations, especially around COVID-19, are ever changing, as well as guidance, this information is current as of February 2nd, 2022 at 2 o'clock Eastern. Because a couple of weeks ago, I did a similar session to this, and we were talking about vaccine mandates and all of the rules and all of the hoops that businesses were going to have to jump through between gathering vaccination info, and for those who aren't vaccinating, all the rules around testing and all of that. And not even an hour after we concluded the webinar, the Supreme Court kind of threw that all out and changed the script. So it is important that this is all current as of today, 2/2/22. So again, we'll do a COVID-19 update. We'll do a legislative overview. We'll dive into some of the federal agencies that focus on employment. So that mainly being OSHA, which is part of the Department of Labor. Also the National Labor Relations Board, which, if you're not familiar with, does have a lot of pull in terms of policy and employment law. We'll also quickly hit upon the IRS. They've got their hands full over there. So if you're waiting for a tax return, don't get your hopes up. Then we'll also kind of look ahead and see what we're anticipating will be trends in employment laws. For those of you who are in multiple states, what to be on the lookout for, what some states have done. Oftentimes we live in a copycat culture, so sometimes when a state introduces a protection or a regulation or a rule or a law, it'll quickly be followed by other states as well. And then we'll kind of whip out our crystal ball and see what we anticipate seeing the rest of this year, and even looking ahead to 2023. If at any time you have any questions, please feel free to use the Q&A function within Zoom here, and we'll answer what we can live if there are any questions. And then otherwise, if there's something that we can't answer live and that requires research, we'll be sure to get back to you with a response. So, as you've probably heard, in terms of COVID-19 and that vaccine mandate that I was just talking about, that it was referred to as an ETS, or an emergency standard from OSHA, that was going to require any business with 50 or more employees to require their employees who were on site to either be fully vaccinated, or short of that, if the employer wished to have a testing option, have the employees testing for COVID-19 on a weekly basis. So the Supreme Court did feel that that was overreach by OSHA based on how the rule was written. Part of that had to do with it not being a universal rule, where it was only pertained to employers of a certain size. I think that helped the case get kind of thrown out, as opposed to what we're seeing in New York, where that rule applies to all employers, and so far that has withstood legal challenge. It's important to note, I know that this is outside of the industry, but similar to us in HR services and payroll, I know that the associations industry deals with people from all walks of life and deals with all different industries, especially when doing business to business work and things like that. The mandate is still in place for healthcare workers. So any company that receives Medicare or Medicaid funding, that piece of the standard, or that rule from the administration in terms of having a vaccination requirement for workers in those healthcare industries, that is still in place. But in terms of the general private employer rule, it was struck down or put on hold. OSHA then formally pulled it for consideration rather than appealing it, or trying to force it through as is. They've taken it off the table. I think depending on what we see in terms of COVID rates, new variants, if things start to really decline in quick order, it may just get put to bed and not come around. But if we see rates start to rise, hospitalizations, positive test rates, all of that fun stuff, if that starts to tick back up, OSHA could go through the more formal rulemaking process. So rather than creating this emergency standard like they did to kind of force it through without the normal open discussion process and all of that, and the ability for people to share their thoughts on a rule like the Department of Labor usually does. If they decide to put forward a rule, they'll probably go through the more formal rulemaking process. So keep your eyes peeled for that. In terms of pandemic relief for businesses, most federal programs ended on September 30th of last year. So whether that be the federal COVID sick leave, the Employee Retention Tax Credit Program, several other pandemic-related stimulus programs all came to a close on September 30th. One important note when it comes to the ERTC, or those employee retention credits, while the program has ended in terms of eligible wages, if looking back you were eligible between March 13th of 2020 through September 30th of 2021, you do still have time to file and claim those credits. So for many businesses who had been using PPP and other sources of pandemic aid and funds, those for many or most, those have dried up. So the ERTC, for those who haven't yet taken advantage of it, and certainly the livery industry are overwhelmingly eligible because of the restrictions in place, and also the effect on gross receipts that the pandemic had, that has served as a new source of funding for businesses who need additional pandemic relief. Also coming across a lot of requests within businesses for reasonable accommodations, and a lot of those COVID related. So for businesses who temporarily allowed people to work remotely, especially, but now want people back in the office setting, or otherwise are putting people back to work, maybe working with the public, what have you. It's throwing a lot of employees into a tailspin, and they're coming up with reasons why they can't do that. why they have a disability, so on and so forth. And some of those are certainly legitimate. Not to discredit anyone's disability claims, but there's a lot of people who really are resisting their company's calls to either come back to the office or get back to more uh, normal work routines and practices. So it's important to keep in mind as an employer, as you start to face these things, that um, there is what's known as the interactive process. And just because someone has a accommodation request doesn't mean you have to grant that as is. Really, your requirement as the employer is to go through the interactive process. So a lot of this hinges on having solid job descriptions, but you want to take a look at the requirements of the job. If you feel that the job really can't be done adequately remotely and it needs to be done on site, then in most cases as a business, that's your prerogative. And you want to take a look at the essential functions of the job and what, if any, reasonable accommodations can be made. Perhaps what the employee is proposing is a reasonable accommodation and will allow them to perform the essential duties of their job. If so, that's great. You can go through those motions and provide those accommodations, and everybody's happy. If you feel that that accommodation request would pose an undue hardship on your business, then you can propose something else, or simply say that you haven't been able to find a reasonable accommodation that can be made. But basically, at the end of the day, if there isn't a reasonable way that will allow this employee to perform the essential functions of their job, then um, there may not be they may not be eligible to work that position, and that that shouldn't come down on you as the employer. So um, sometimes it's an extreme example, but I use it when I talk to many industries. It just happens to fall within yours. But if you have a driver who loses their vision and is no longer licensed to drive, there's no real accommodation that can be made for them to continue to drive. So while that's the most extreme case, and unfortunately a lot of the real life applications have a lot more gray to them rather than the black and white of that example, it's just something to keep in mind, that a lot of times employers can be caught off guard and think that if an employee comes in with a doctor's note or whatever it may be, that you automatically have to do whatever that says. And while you have to respect the restrictions and shouldn't make them do anything that the doctor says they shouldn't be, you're not bound to keep them employed in the same capacity necessarily, depending on what the circumstances are. So always best to talk with an HR professional and or legal counsel when these things arise. But just keep that in mind, and don't overcommit yourself to anything you don't need to. So a lot of questions we have are, when we get a lot of phone calls. Hey, I had an employee test positive. I had an employee who was a close contact of someone with COVID-19. What do I need to do? So here lies the most recent CDC guidance for a few different applications over the next couple of slides. So, this is CDC guidance, not necessarily the law of the land, so to speak. We generally advise that at a bare minimum, employers do follow the CDC guidance. If you run afoul of it, there could potentially be, say an OSHA claim that you're not providing a safe workplace and you're outside of the CDC guidance. So it's generally a good idea to do the CDC guidance at a bare minimum. Obviously, for some businesses, especially those that are dealing closely with the public, they may want to have additional measures or additional protections, or be a little more cautious or conservative with how they handle COVID cases or close contact within their business. And that's perfectly fine if you want to be more stringent. And I know people have all varied opinions on that, and um, we're not here to get political or anything like that with it, but really, at the end of the day, if you're following whatever the current CDC guidance is, at a minimum, you should be okay. And certainly, if you want to do more, um, our friends in the airline industry have largely still stuck with vaccine mandates for their industry, at least for positions that are customer or client facing, passenger facing. and those were often put in place before there was even talk of a federal mandate, and have stayed through, and by and large those have stood up in court. So I use the airline industry often in my examples for businesses who want to do more. Those have been accepted by the courts to date. But with that being said, let's go over what the current guidance is with the CDC as of late December 2021 is when I believe they released this. So if you do have a COVID positive employee lets you know that they've tested positive, and this is regardless of whether or not they're vaccinated. So same rules apply for vaccinated or non-vaccinated in this case. That person should stay home for 5 days, so that's a reduction. It used to be 10 days. If they have no symptoms, if they're asymptomatic, or their symptoms are resolving after 5 days, so their condition is improving, they can leave their house, but they should be wearing a mask for 5 additional days. So you could theoretically allow them to return to work after 5 days, provided that they are symptom-free or the symptoms have largely improved, but they should continue to wear a mask for at least another 5 days. If they have a fever, they should continue to stay home until that fever resolves. So that's if you have a positive case. Things get a little bit more tricky if someone says they were exposed to COVID-19 as a close contact. And the rules are different in these cases, whether someone is vaccinated or not. And while the CDC still defines fully vaccinated as someone who's received 2 doses, in most applications, the booster isn't required for fully vaccinated status, but under the current CDC guidance, it does come into play. So in terms of this first set of rules, or a little bit more cautious rules for COVID exposure, this first list would be for folks who are unvaccinated, who are vaccinated and haven't received a booster, or if they've received the second dose. If they haven't received their booster, their second dose was more than 6 months ago, or if they're a Johnson & Johnson vaccine recipient, that was more than 2 months ago. So someone who's unvaccinated or not boosted, or could be more susceptible than others, they should stay home for 5 days, and then after that should continue to wear a mask around others for 5 additional days. So essentially the same treatment that you would for someone who is tested positive. If for some extreme reason they can't quarantine for any period of time, they do need to be wearing a mask for all 10 of those days. Whenever possible, and I know this can sometimes be a challenge with availability for scheduling and for the availability of home tests, ideally this employee should get a test on the 5th day after their exposure. And if at any point they develop symptoms, they should get tested at that point and stay home pending the results of the test. So even if it's fewer than 5 days or greater than 5 days, if they start to develop symptoms, they should get tested at that time. Now, for workers or folks who are fully vaccinated, have received a booster, or more recently, within the last 6 months, received their second dose, or within the last 2 months, received their shot of Johnson & Johnson, there isn't currently a CDC guidance or recommendation that those folks need to necessarily quarantine at all. They can continue to report, provided they're wearing a mask for 10 days. Similarly to the above, they should get a test on day 5 whenever possible. And if they develop symptoms, they should get tested right away. Now, as I said, if this is beyond your comfort zone as an employer, if you still want people, regardless of vaccination status, to quarantine, then that's certainly your prerogative, and you can do that. It's up to you. This is just what the CDC guidance is as a baseline for right now, and what you should be doing, if not more. One thing to keep in mind before I move into more of the legislative and government stuff, I know we do have a lot of members who have employees in Massachusetts or are headquartered in Massachusetts. So while the federal COVID sick leave has gone away, the state of Massachusetts, along with several other states around the country, do have their own emergency COVID sick leave. So in Massachusetts, if someone needs to quarantine, if they test positive, if they're going to get vaccinated or they're caring for someone under any of those circumstances, as an employer, you are required to provide up to 40 hours of emergency COVID sick leave. The maximum amount of pay that someone can really receive for those 40 hours is $850. The benefit is capped out at that. As an employer, you can be reimbursed for that expenditure. What you need to do is go to Mass Tax Connect and enter through there the information about the employee. There's a form that the employee needs to fill out for you to keep on file, but you can claim reimbursement for wages paid under the COVID emergency sick leave. But again, for your Massachusetts employees, you do need to be providing that 40 hours. If you are in other states, feel free to reach out to us. We'd be happy to advise you whether or not there is something similar in that jurisdiction. Okay, so what's going on at the government level? So first, a update on what's known as the PRO Act. So the PRO Act was a pretty large bill that passed the House and was introduced to the Senate and kind of stalled out there, at least in the most recent legislative session. The PRO Act was something that would have done a few things. Definitely ushered in a more organized labor and union-friendly landscape across businesses, a lot of protections and encouragement for unionization efforts. Also, a lot of scrutiny on who can be considered an employee versus who can be considered a independent contractor. So some kind of following suit of a lot of the states who are stricter with those definitions. We'll see what happens with that, but the PRO Act as one big bill, similar to the Build Back Better bill, looks like it has a little bit too much to it to pass as it is. One thing that they are looking to do as part of it is give the National Labor Relations Board more power to enact punitive damages and civil penalties when an employer violates labor laws or violates the National Labor Relations Act. So the National Labor Relations Act we'll get into in a moment when we talk about the NLRB, but it essentially protects employees' rights, their rights to organize, their rights for protected speech, so on and so forth. So there is a chance and there is a bill out there that would give them, aside from just assessing back wages and things like that, give that agency or that government body more authority and more power to fine and penalize companies a little more heavily. We are nearing the midterm elections, so what that means is fewer and fewer members of the government will want to rock the boat in terms of new legislation, so things might get a little bit quiet at the formal bill level. But what that also means is that the actual government agencies may do more rulemaking, and the president may do more through executive orders. So we'll talk in a second about Department of Labor and all of that and what they've got cooking, but there may be a reduction in what actually happens in the formal kind of bill making process. One bill that does look headed for passage is the Pregnant Workers Fairness Act. So this would prevent any sort of discrimination against pregnant workers and provide other protections and rights for them as employees. So that does seem to have bipartisan support. Once the final version of that looks solid, we'll be releasing some information about it. Many states do already have pregnant worker protection plans and bills and laws, but this would be at the federal level and apply to all companies across the country. For those of you who are larger businesses, have 50 or more full-time equivalent employees, you're probably already familiar with the Affordable Care Act and the health insurance reporting that you have to do each year. They are in the process of permanently moving the due date for the forms you have to supply to your full-time employees from the end of January to the end of March. So while they're working that out, this year they did extend that deadline. So if you are subject to the ACA, you do have until the end of March to get those forms to your employees, provided you've otherwise filed with the government electronically. Okay, so a lot of things cooking at the federal agencies and at the Supreme Court. Obviously, there was the vaccine mandate case, which we've already talked about. Also an interesting case that probably won't apply to the Livery Association and livery industry because you're ground transportation, but it really depends on how the opinion is ultimately written. But we do have our friends in the airline industry really looking for some clarification and fighting some of the state wage laws and state labor laws, just because so much of the work of flight attendants in particular is done in the air, and it's really hard to say where is that work being done. So that's all going to be sorted out by the Supreme Court this session. They're also going to sort out the validity and the legality of what's known as mandatory arbitration. So some businesses will have employees at the time of hire sign an agreement that says that if they have a dispute or wish to take legal action against the company, that they're forced into arbitration rather than going through the court system, and instead an arbitrator hears the case. So there's a big case challenging that, the validity of those agreements that employees enter into. So the Supreme Court will be weighing on that in the months to come. A couple other cases that they're going to be hearing this session will be regarding the power of federal agencies and their ability to interpret laws at the state level, and then also a case which may govern limits on retirement plan fees that are charged to plan participants as well as companies who sponsor plans. So as promised, I just want to give a quick update in terms of what's going on at the IRS. So this doesn't necessarily pertain to employment law or HR, but I know a lot of businesses have submitted employee retention tax credits or are otherwise expecting money or refunds from the IRS. But based on some articles recently published, they are truly in a crisis mode. So as of the end of 2021, there was a backlog of over 6 million tax returns that have gone unfiled, as well as 2 million amended returns. So just a huge backlog as the new tax year started last week. So just when they were hoping to catch up, there's going to be more coming in. Also, their staffing has been reduced through both budget cuts as well as the impact of COVID-19 that we're all feeling in terms of struggles to hire people. Right now, their staffing is around 1970 levels. They do have 15,000 call center employees, but if you've tried to call the IRS recently, I'm sure you've experienced very long wait times. That's because last year they fielded over 240 million calls, and only 9% of folks waited around for someone to pick up the phone and respond. While they do have web resources available for businesses and individuals to check the status of their return, those are getting walloped as well, over 500 million visits to their Where's My Refund site. So in terms of what to take away from this, if you do have the option in your filings, whether it be personal filings or business filings, I do highly recommend using the e-file system rather than a paper return. Paper returns are just terribly backed up over there. So if you do have the opportunity and the ability to e-file, I highly recommend that. And then also, this isn't applicable. So when we talk about ERTC, they're making those be done via amended returns. They're making them done via paper. They're requiring that the refund be sent via paper check. So some things are out of your hands, but If there are returns and there is the opportunity to receive a refund or a payment via direct deposit, we also highly recommend that. The timelines on those are much quicker than paper forms or paper checks. Okay, so over at the National Labor Relations Board, for those of you who are unfamiliar, the National Labor Relations Board is basically a panel made up of individuals with the majority by one being of the president's party. And what they do is they have one person as general counsel in addition to the board. The general counsel decides what cases they'll hear, what complaints they'll bring in, all having to do with supporting and defending the National Labor Relations Act, which protects, again, employees' rights, their rights to organize, their rights for protected speech, so on and so forth. So looking back at the National Labor Relations Board in the Obama administration, there was a lot of action around employee handbooks and the way that policies were worded and written, and whether, being too vague or other language that could be chilling of employees' rights. A lot of businesses needed to amend their handbook policies to make sure that they were within the guidance of the National Labor Relations Board. The next administration moved in and some of that changed. They changed their outlook on policies, instead taking the view that they would assume that things were lawful and in good faith unless something was overwhelmingly chilling to employee rights. But just like the seasons, things change. We've got a new National Labor Relations Board sitting now, or at least some new members. And they are aggressively seeking cases on certain topics and certain areas where some decisions had been reversed or put in place that they think they'll disagree with. So they are actively requesting cases about independent contractors and whether folks are lawfully classified as independent contractors when they should perhaps be classified as employees. They've also gone after Google, the New York Times, and Amazon for not following the latest and greatest rules around employee unionization and elections and election rules and meetings and the ballot process. So all of that, they have gone over those three businesses in particular, following recent unionization efforts at those organizations. They are also looking to weigh in on severance agreements and certain language within severance agreements. So if you've ever seen, or hopefully not, but perhaps signed a release of claims as part of a severance agreement, a lot of times you'll see some language in there that requires the signor to keep the amount of the settlement or the amount of the severance confidential. You'll also sometimes see a non-disparagement, or more often a mutual non-disparagement clause, which says in agreements in exchange for receiving the severance, you'll keep the amount of the severance confidential and you won't disparage the company in any way. It sounds like the current iteration of the National Labor Relations Board takes issue with that, so they may look to ban that kind of language in severance agreements, or ban the validity of it at least. So we'll see what happens there, but that could be big news. Another case that they are taking on right now is with Whole Foods. So you may remember at the very beginning of the pandemic, there was a dust up where some employees walked out from Whole Foods. They protested because they had been wearing Black Lives Matter masks while working, and Whole Foods did not allow that. There was some back and forth. Eventually they came into some sort of agreement. Whole Foods gave them some things that they could wear, but the National Labor Relations Board has weighed in and found that they were infringing upon the employees' rights, that the employees have the rights to talk about their working conditions, and inherently their working conditions involve racism. So it should have been lawful for them to wear those Black Lives Matter masks. There's still a lot to be said and a lot of arguments to be made around this case, but should it prevail in the employees' favor, it could really require businesses, and I know a lot of livery businesses do have dress code policies and appearance policies and things like that, and may require businesses to take another look at those policies to make sure they're in line with the current viewpoint and current rulings of the National Labor Relations Board. Department of Labor is also keeping very busy. I often like to take a look at the press releases, so that doesn't encompass all of the action that they're taking, but just in January alone, there were over 20 press releases that involved fines or penalties issued to businesses for violating various labor laws, OSHA, so on and so forth. So they're very aggressive. They're got open eyes and open ears. They're, at least in my experience, they're moving more quickly than they have previously when it comes to a complaint coming in from an employee or a former employee, especially on the OSHA side. They're acting very quickly. So when we talk about keeping up with, at a bare minimum, CDC guidance when it comes to COVID, you really want to do that, because what we're seeing is that when an employee complains and says that, you know, going to OSHA and saying that their employer is not providing a safe workplace, OSHA's jumping all over that to the extent that they can, given their staffing challenges as well. So they have, just a month or two ago, the DOL did formally enter into a partnership and an information sharing agreement with the National Labor Relations Board, who I was just talking about. So there will be some back and forth between them. So if you hear from one, you could very well hear from the other as well. And I did just want to share one case that did recently occur. You may or may not have heard of it, but it's in the automotive industry, not necessarily the livery industry, but I believe it was a garage or a mechanic or an auto body shop. An employer and an employee had a real falling out, an argument. The employee ended up quitting, but was owed $931 in final pay. Much to the chagrin of the employee, the employer showed up with a truck bed and dumped $931 in pennies on the employee's driveway, all over the driveway. Oily pennies too, not shiny new pennies, but dirty, grimy pennies. And then also provided him with a pay stub upon his request that was filled with expletives and derogatory statements about the employee. And then finally, the employer also, via the business's website, shared some thoughts about that employee on the company website. So the Department of Labor took on this case. They did find that the employer was committing retaliation against that employee and that their actions were unlawful. And unfortunately, much like we advise our clients, when there's one case, the Department of Labor doesn't just focus on that one employee and that one complaint. They did go forward and do a more formal audit and review of this employer's pay practices. And at the end of the day, that those $931 in dirty pennies and whatever joy that brought them to do that ended up costing them $36,000 in damages and back wages to this employee and some others who looked like they weren't paid correctly for overtime. So just a word of caution, the Department of Labor is very active in going after businesses when they receive a complaint. Okay, so should you work with or know of any or be considered a federal contractor? There are some new rules for federal contractors that were recently enacted this year. First of which is a $15 minimum wage. There are some exceptions to that based on the work being done, but by and large, there is now a $15 minimum wage for anyone acting as a federal contractor. And there is now, in addition to just being required to have an affirmative action plan, there is a new reporting system called AAPVI, where federal contractors are going to have to formally submit their affirmative action plans to the federal government. The window for doing that will be March 31st through June 30th of this year. So if you are considered a federal contractor based on the work that you do want to make sure you get up to speed with that. There is also a collaboration between the Equal Employment Opportunity Commission and the Office of Federal Contractors that's really urging equity in hiring and providing some resources and some guidance around that. So we'll see where all of this takes us. And then finally, in terms of state laws and regulations, we're seeing a lot of states enact non-compete limitations or outright banning them. So really setting guidelines and a framework for when a non-compete can be valid. So sometimes that, depending on the state, it will depend on the employee's position, whether it's a exempt professional position or an hourly person. Some states don't allow them for hourly non-exempt workers. There also may be restrictions on the amount of time that a non-compete can be in place, or the amount of geography that it can cover. We're also seeing a number of states adopt natural hairstyles as protected classes, so allowing employees to go outside of a company's normal dress and or appearance or hygiene protocols to allow for natural hairstyles in the workplace. Illinois has gone ahead and extended their protections for disabled workers to also apply to workers and individuals who have an association with someone who's disabled. So where this may pop up is if you have an employee whose spouse or parent or child is disabled, and what, if any, accommodations need to be made for that employee to work around that. California is also always an outlier. They penalize or require employers to pay a certain amount of money whenever an employee misses a break. And what they've essentially done over the last few months is create a higher amount of money that would need to be paid to those employees when they are missing their breaks. As I shared, Massachusetts, Colorado, New York, a number of other states do have COVID sick leave laws in place and that are still active even after the expiration of the federal program. So again, if you're a multi-state employer, and this includes multi-state in terms of having remote employees, so even if all your on-site employees are working in Massachusetts, but you've got some people who may be doing dispatch or scheduling or sales or whatever from a remote environment in another state, you do need to become familiar with the employment laws in those states as well, because those employees are considered employees of the states where they're performing work. So in terms of looking ahead, we always keep our finger on the pulse of litigation trends and kind of what's entering the courts. We are seeing a lot of cases of COVID discrimination, again, complaints that an employer did not have a COVID-safe working environment. Also seeing a lot around civil rights and discrimination, a lot of cases around that. Also a lot of litigation around wage and hour, so overtime, and when someone is being paid overtime, what compensation is being factored into that rate that time and a half needs to be based off of. So if there are defined bonus programs and commission structures, a lot of times those have to be factored into the regular rate. It's just not their normal hourly rate necessarily. So a lot of scrutiny of overtime and overtime rates. Also a lot around misclassification. A lot of this is pandemic related. So, something to keep in mind is you might have had an employee whose job duties were largely exempt or at a level that you could pay them a salary and not have to pay them hourly, not have to pay them overtime, but because of staffing shortages or again, the pandemic, whatever it may be, you may have an employee who all of a sudden is doing a lot of work that's, at the level of an hourly employee, and, all of a sudden their primary functions are no longer exempt level duties. And we're starting to see some cases where employees are making that claim and saying, hey, yeah, I was an exempt employee. I was a manager, an assistant manager, a supervisor, but because of our staffing, my day-to-day is largely non-exempt work. So yes, I was a supervisor here at the coffee shop and was performing managerial duties prior, but nowadays I'm really just pouring all the coffee, so I should be eligible for overtime. Also a lot of litigation around remote work, how many hours people are working, what's being reported. Again, employers not realizing that they were subject to certain state laws because of where the employee was performing their remote work. So parental leave, disability leave, what have you. A lot around that as well. And then finally, in terms of things to look for in the months and year ahead, I think a continuing trend of what I was talking about, just fights over jurisdiction. So earlier on in the pandemic, a lot of states were pretty easy about just saying, hey, yeah, we understand that you can't have employees working at your offices. So if they're working from home and that happens to be out of state, you can continue to just treat them as they were before. But now that this has gone on for so long, states are really cracking down on that and saying, hey, yeah, if you have an employee who lives in our state and they're working from home, you really need to start paying employment taxes or perhaps other taxes in our state. We want that revenue, we want that income. Same also applies to employment laws. So, Massachusetts is a great example. They have the paid family medical leave here. And that only pertains to employees whose workplace is Massachusetts. So if you have an employee who had been working in your offices, but now for on a permanent basis, especially, is going to be working from their home in New Hampshire, they may not be a Massachusetts employee anymore and really may not be eligible for a paid family medical leave if they need to use it. I think we're also going to see some real serious Department of Labor action around independent contractors and some rulemaking around who can be considered that. Depending on the setup of your business, that could be good news or bad news. We'll see. I know we're all familiar with all the efforts that the disruptors within the industry and ride sharing has had and their ability to use independent contractors. So this could create some limitations on them. Obviously, we know about the war chest that they have and what they were able to do in California with that ballot initiative, but it'll be really interesting to see how that unfolds at the federal level with the Department of Labor. We also expect to see more guidance and more rules around unionization. So how quickly a organizing group can have an election, what that process looks like, whether employers are allowed to have required meetings to talk about unionization efforts, what they're allowed to say in those meetings, what they're allowed to distribute, what they're allowed to communicate, whether or not employees are allowed to use company property or company resources such as email to talk about unionization efforts. So a lot to be hashed out there. Just be sure you're following the latest and greatest with that. We will keep the association website up to date with all of our webinars, our recordings, our other resources, and if you haven't already, please do check out the association website where you have a link to ask HR questions of myself and our team. But as I said before, we do also expect some changes to handbook policies over the next year based on NLRB decisions. So a lot to keep your eyes peeled on, a lot to keep your finger on the pulse of, but here at MP, we eat, sleep, and breathe HR. So we're keeping on top of it so you don't have to. Just make sure you're getting our communications and our emails, and we will keep you up to date.
Paul,
so that does conclude my session. Without any further questions, I'll hand things over to Rick to close us up.
Yeah, Paul, if you don't mind, I'd like to raise a few questions in your crystal ball slide.
Sure.
Leads me to feel like, gee, could things get any more complicated?
Yeah.
So right now it appears that we can ask the candidate if they've been vaccinated, and if they have not, if they are willing to undergo weekly tests. Testing, is that correct?
That is correct. Yeah. So, as I said, while the vaccine mandate and the requirement to do that has been thrown out at this time for businesses who have wanted to have a greater sense of that, or require vaccination, ask about collect vaccination status of their employees, or have them submit to weekly testing if they're not vaccinated. All the government agencies and all the courts to date have supported those efforts by employers. So yeah, in terms of as of now, yes, employers can do that if they want to have those policies and that structure in place. And I'm sure it can be effective for clientele and marketing efforts to be able to say that you've got a vaccinated workforce or a tested workforce. So yes, you are allowed to do that.
Excellent. I have some follow-up questions, if you don't mind. So
sure.
So does that mean a ground transportation company can request a copy of the vaccination card?
Yes. So
Okay.
when we look at what the rules were going to be, sometimes that's good guidance for what might be permissible. Um, in most cases, you could definitely ask, you could require a copy of the vaccination card. There was some guidance that, hey, if someone lost it, here's what they should do. They should ask, the provider or their state health agency for a new version of the card. If for some reason it was just impossible, there was an out for employees to fill out this kind of lengthy affidavit and go into great detail about their vaccination history and records. But I think that'd be in a really extreme case. And in most cases, yes, you can ask for a copy of the card.
Okay. Assuming free testing is not available, is the ground transportation company on the hook to bear the financial burden of the weekly testing?
No, at the federal level and at most state levels, the courts and the agencies and the state governments have said that you can put that expense on employees. One exception, because I know we've got reach throughout New England, New Hampshire surprisingly has bucked that trend, and so New Hampshire has specifically said that as an employer in New Hampshire, if you're requiring employees to get tested, that the employer does need to assume that cost and responsibility. But that is an outlier. The other states that I'm familiar with, at least, have allowed employees to have to bear that expense.
Okay, great. And just switching gears just a little bit, and you mentioned what occurred in California with AB5 and Prop 22 relative to Uber and Lyft and independent contractors, and the AG in the Commonwealth of Massachusetts has brought suit against Uber and Lyft relative to misclassification. Do you have any updates on that? It seems information goes underground for a while and pops up again.
Yeah, so I mean, at least over in California, that's the law of the land. Yeah, Massachusetts in particular, you're right, things have been quiet. I haven't received an update on where things stand there. It'll be interesting to see how this plays out. I think Massachusetts is kind of in a holding pattern, and maybe they've got some insider information since Marty Walsh, the former mayor of Boston, is the current secretary of the Department of Labor, so he heads up that division. I have a feeling they're kind of waiting to see what, if any, action over the next few months the federal Department of Labor takes around creating a federal rule. And I also think the ride sharing companies, not to say they're short on cash by any means, but they might be preserving their war chest to see what they need to go after, whether that be state laws or the federal rulemaking process.
Yeah, tomorrow, the association has set up a meeting to chat a little bit with some knowledgeable parties in California.
Oh, cool.
Yeah, just to really hear from the horse's mouth, as it were, what their experience was with AB5 and Prop 22. Since it looks like there could be a ballot initiative going on in the Commonwealth.
Yeah, so we'll see how that shakes out. But I haven't received a formal update on that in particular just yet. But I'll be sure to look into that. And this is now part of a monthly webinar series, so we'll be doing another one the first Wednesday next month at the same time. And regardless of the topic, I'll try to do a brief industry update at the top just to make sure we're all on the same page, as well as sending stuff out as it is relevant.
Excellent. Paul, thank you so much for today's presentation and our past work together. And we look forward to doing this every Wednesday.
Awesome.
Every Wednesday. I'm sorry. First Wednesday of the month.
Yeah, likewise. No, I really enjoy the session and look forward to the rollout. Thanks so much.
Yep. Thank you, everybody.